issue of financial disclosure crops up time and time again in Hong Kong divorces, particularly where substantial assets are involved or where one spouse controls the family's finances. In Hong Kong, both parties in a divorce have a duty to provide full, frank, and clear disclosure of their financial circumstances. This duty isn't just a formality, it's a cornerstone of the court's ability to achieve a fair and equitable division of assets. Disclosure is meant to be transparent and covers worldwide assets and income. That means disclosing not only your current assets, savings, property, investments, but also debts, income sources, interests in companies, as well as interests in any trusts. The court expects honesty and completeness. It also expects a party with complex financial affairs to explain them clearly. If you're divorcing in Hong Kong, you are required to put all of your financial cards on the table face up. The court requires each party to complete the Form E statement, which is a sworn financial affidavit supported by documentary evidence. This is the mechanism through which both sides have visibility into the other's finances. While it's a fairly structured process, it relies on the honesty of each party. Where one person withholds or misrepresents information, the court will allow the other spouse to take steps to uncover the truth. As family lawyers, we often develop an instinct for when something doesn't quite add up. Perhaps the lifestyle during the marriage doesn't align with a declared income. Maybe there's a sudden transfer of assets to third parties, or company accounts that show unexplained expenditure. While these signs don't always mean deliberate concealment, they do justify deeper inquiry and sometimes formal discovery steps through the courts. The family court takes a strict approach to parties who fail to fulfill their disclosure obligations. Non-disclosure is treated as a form of misconduct. When the court finds that information has been withheld, there are a few possible outcomes. The court can make orders for further disclosure, compelling the production of certain documents. The court may draw adverse inferences, meaning it assumes the undisclosed assets exist and attributes them to the non-disclosing party. In serious cases, there can be cost orders or even contempt proceedings if somebody deliberately disobeys a disclosure order. We work with forensic accountants and valuation experts to identify inconsistencies and follow financial trails. This kind of investigation helps bring the full picture to light, which ultimately assists the court in making a fair assessment. If you're going through a divorce and suspect that your spouse isn't being forthcoming about finances, try to gather as much evidence as you can. Keep copies of bank statements, of tax records, and communications about money. This will help your legal team build a clear picture of your financial history. But please resist the temptation to overstep boundaries by accessing your spouse's private information, such as accessing email accounts or taking documents belonging to your spouse, as this self-help approach may backfire. Disclosure is fundamental to fairness. When parties are open and honest, settlements are quicker, costs are lower, and everyone moves forward more constructively. We believe that clarity and accountability are key to achieving fair results in family law. Whether you're the financially stronger or weaker spouse, the goal is always the same: a complete, honest, and equitable resolution.